Good morning. Welcome to our case of the week for June 29th, 2021. My name is Kelly Twigger. I am the CEO and founder of eDiscovery Assistant and the principal at ESI Attorneys. Thanks so much for joining me this week. As you know, if you tune in with us each week, we are broadcasting live through our partnership with 𝐊𝐿𝐴𝐶 for our Case of the Week series that is available to be streamed on LinkedIn, Twitter, and Facebook, as well as YouTube. You can tune in on any platform, and in the comments section for whatever platform you're viewing, you'll see a public link to the case that will take you to the actual decision in eDiscovery Assistant that we are discussing this week. You will also see in there a link to our 2020 eDiscovery case law report that we did in cooperation with Doug Austin at eDiscovery Today. In that report, you'll see a breakdown of case law from 2020, as well as write-ups of each of the cases and links to a video broadcast that we've created on each of the cases on the Case of the Week series here, as well as additional breakdown of information and how courts are looking at decisions and what issues are key. We've also just launched our new website over at eDiscoveryassistant.com, so please hop on over and take a look. All right, let's dive into this week's case. This week's decision comes to us from an antitrust case filed by a class of plaintiffs against Facebook in a decision or in a matter called Klein versus Facebook. This is a decision from the Northern District of California and is from June 3rd of 2021. This is a case that was filed in December 2020, so it's not incredibly old. It was originally assigned to Judge 𝐊𝐿𝐴𝐶 and then was referred to Judge Virginia Demarchi. In this, the plaintiffs are bringing multiple claims for antitrust violations against Facebook. There is currently a motion to dismiss pending in the case. And if you follow these sorts of things, you'll see from the Wall Street Journal yesterday that district court in the District of Columbia dismissed a number of antitrust actions against Facebook that were brought by the FTC that are similar to claims in this case. So we'll see what happens there. The dispute currently before us that we're looking at today is that the parties disagreed on the entry of a FRE 502D order. And the reason I wanted to raise this with you today is because using a 502D order is just critical these days when we're dealing with ESI. And if you're familiar with Judge Andrew Peck, who was formerly a magistrate judge in the Southern District of New York, Judge Peck has said many times in public speaking engagements that a failure to use a 502D order is basically malpractice. So this is an opportunity in using a 502D order to protect your client from any inadvertently produced privileged or otherwise protected information. And so I want to talk to you today a little bit background-wise about how FRE, Federal Rule of Evidence 502D, came into being and why, and what sort of impact it has here. And then we're going to address the various disputes that the parties raised in their 502D order before the court here and how they were resolved. So background-wise, when we had the original amendments to the Federal Rules of Civil Procedure that really brought electronically stored information into play in the federal rules prior to 2006, when the federal rules were amended, we only had the definition of document. 2006 amendments, the federal rules and Rule 34 and Rule 26 specifically defined documents to include electronically stored information, or ESI. And as part of those amendments in 2006, Rule 26b-5 was amended to discuss information that's produced. And in that section of the rule, they specifically noted that if information produced in discovery is subject to a claim of privilege or of protection as trial preparation material, the party making the claim may notify any party that received the information of the claim and the basis for it. The section then goes on to describe the process by which the receiving party has to return it. But the key to 26b-5 is that the party who inadvertently produces the information has to recognize that they have inadvertently produced it and contact opposing counsel. And then, only then, do opposing counsel's duties kick into play. Well, that's pretty problematic because, you know, if we inadvertently produce information, the likelihood of realizing that you've inadvertently produced information is low, unless there's some specific analyses that are done. But presumably you're taking all of your steps done to reasonably protect any attorney-client information prior to production. And there's not usually a lot of analysis post-production. So the notion under 26b-5 was a bit hard to stomach for pretty much everybody in the eDiscovery space. And as a result, there was a lot of public outcry around that section. And in September of 2008, Federal Rule of Evidence 502 was enacted. And there are multiple sections of Rule 502 that deal with the production of privileged or protected information. There are two separate sections of Rule 502 that were really enacted to provide a more workable framework to evaluate when a waiver occurs in the event of inadvertent production. So Section 502B creates an analysis for waiver based on inadvertent disclosure. The disclosure must be inadvertent, and that word is specifically used in Section 502B. The producing party must have taken reasonable steps to prevent disclosure and then followed the process in 26b-5 to recover the privileged material, which means asking for it back, right? And so that presents the same problem that we already discussed with Rule 26b-5. Now, 502B essentially eliminates a couple of the smaller sections of Rule 26 as it relates to inadvertent production, right? But it still requires that the party that produced the information go and ask for it back. And you also need to show that you took reasonable steps to prevent disclosure in the first place. Now, Section 502B or 502D really does something different. 502D says the parties can work with the judge to issue an order that says straight out inadvertent production is not a waiver for the case, meaning that by virtue of Federal Rule of Evidence 502C, that there is not a waiver for any other federal or state case if there is inadvertent production under a 502D order. The language of 502D itself says controlling effect of a court order. A federal court may order that the privilege or protection is not waived by disclosure connected with the litigation pending before the court, in which event the disclosure is also not a waiver in any other federal or state proceeding. So that's really important. If you have a 502D order, you're preventing yourself from disclosure. But what is noteworthy is that 502D does not contain the word inadvertent. So 502B does contain inadvertent, 502D does not. In our case law database in eDiscovery Assistant, we use separate issues for 502B and 502D. There are certain instances where parties do not enter 502D orders, and thus the analysis when there is inadvertent production of information is done under 502B. So if you're an eDiscovery Assistant user, or if you're looking for case law under both individual sections, you'll want to use those issue tags within the database to sort your data. Okay, so specific facts of this case with that background of those rules in mind. As I mentioned, it's an antitrust case, so we've really got an asymmetrical litigation where Facebook is providing all of the data, right? You've probably got some data from plaintiffs, but as a general rule, Facebook is providing all of the data, and that's always an important consideration from a proportionality perspective, but also from a perspective of drafting these kinds of rules. The party most likely to have an inadvertent production is Facebook, and so Facebook wants to be able to take additional steps to provide a process by which that information can be provided. These cases also involve tons and tons of documents, and so and because there are also government investigations that are pending here that may not have the same tight controls as private civil litigation, there is a potential for the inadvertent disclosure of information and a need for Facebook to pay special attention to how the process is to handle data that may be inadvertently produced. So in this case, there are multiple sections. The parties proposed a 502D order, and there are disputes about what the language should be for each one. And so I wanted to address each individual section in part because it's really important as you're considering putting a 502D order in place, how you address each one of these issues or whether you need to address them. So there is very simple language in what is the 502D order that Judge Peck has always advocated when he was on the bench. That form is included in eDiscovery Assistant. And it's very simple. You know, it essentially mirrors the language of Rule 502D and provides that there is no waiver. However, in cases like this case, where you want to talk about a broader set of protected documents and not just privileged documents, there needs to be more thought given to the language of the 502D order. And that's what we're looking at in this decision in the Klein case. Okay, so the first issue that the court looked at is whether the order should be limited to inadvertent productions of privileged material. And as I mentioned, this comes up because 502D does not contain the word inadvertent, whereas 502B does contain the word inadvertent. And the court looks, as the courts regularly do, to the commentary that the legislature drafted when it drafted this rule. And the commentary to Rule 502D indicates that this subsection was intended to allow for court orders that protect against waiver in circumstances that do not meet the criteria of 502B. And here's the quote of that commentary. The court order may provide for return of documents without waiver, irrespective of the care taken by the disclosing party, end quote. So what we're doing is eliminating the reasonableness requirement of both 26B5 and of 502B. At the same time, the commentary also reflects that Congress did not intend to authorize the district courts to completely alter applicable law regarding the waiver of privilege. The 502 addendum to the advisory committee's note states the following. This subdivision is designed to enable a court to enter an order, whether on motion or one or more parties on its own motion, that will allow the parties to conduct and respond to discovery expeditiously without the need for exhaustive pre-production privilege reviews, while still preserving each party's right to assert the privilege to preclude use in litigation of information disclosed in such discovery. That's close quote. The reason that that's very important is that the legislature has set out, here is the exact intent of Section 502D. And so the court is looking at that. When you're looking at the language of the Federal Rules of Civil Procedure in eDiscovery issues, you will find the comments to those rules are very key in laying out exactly what the legislature intended in drafting those rules. And this is no exception. So the court then enunciated the purpose of the 502D order as to provide a mechanism for protecting legitimate claims of privilege without requiring an exhaustive pre or post-production review of documents disclosed in discovery. And that mechanism for challenging post-production claims of privilege in a way that does not unfairly prejudice a receiving party who may have already relied on the information. So think about a situation where you've inadvertently produced information, you don't realize it for weeks afterwards, and in the meantime, the receiving party has found the information and has legitimately started using it to create strategy, to invoke deposition questions, all kinds of things that the party might have already begun using the information for. And the court says there has to be a process that does not unfairly prejudice the receiving party who may have already started to use the information because they did not know it was privileged information. There are multiple sets of circumstances that we've been involved in as counsel where there are legitimate questions as to whether or not information is privileged, right? There can be questions as to whether or not advice given by in-house counsel is business advice versus legal advice. There can be questions as to whether or not a common interest doctrine applies that makes a document subject to privilege. So it's not always cut and dried as to whether or not privilege applies. And so when there are gray areas, the process needs to make sure that it is appropriate for both sides. And so the court really looked at addressing both those concerns and also the inadvertent issue and proposed new language of what the parties had deemed protective documents to make clear that the order applies to documents and accompanying metadata that are produced and disclosed in this action as to which a party asserts a claim of privilege or protection. So what the court really did was revise the party's proposed language to deal with the issues that it found. Okay, next section were sections 2 and 5 of the proposed order that laid out the procedures that apply when one party issues a clawback notice for a protected document, right? This is the procedure that we just talked about. The plaintiffs wanted to challenge, they wanted essentially to say that a challenged document should just be sequestered, that they shouldn't have to destroy or get rid of it until the court rules on it. On the other hand, Facebook wanted any potential privileged material to be destroyed pending the resolution of a challenge. Court really looked back at the analysis of 26b-5, as well as the federal rule of evidence, and says that, you know, the party's dispute here really arises from the language of 26b-5b, that after being notified of a privilege claim, a party must promptly return, sequester, or destroy the specified information and any copies it has, and must not disclose the information until the claim is resolved. So that language is kind of our baseline. Excuse me, goodness. The court then notes that both of the parties' positions deviate from that language, right? I mean, the language says sequester or promptly return or destroy, and they're both arguing that it should either be sequestered or destroyed. So in looking at it, the court says the plaintiffs really want to challenge the actual claim of privilege, which is not contemplated by Rule 26b-5, and Facebook wants to require return or destruction of the document to preclude the party from examining it, neither one of which go to procedure. So the court then notes that if the receiving party has already examined the document and developed work product referring to the document, it's neither practical or fair to require that that party destroy it pending resolution. So what the court does is really a happy medium. It revises the language to set out a process that essentially says, hey, if the party has already developed work product, that work product has to be sequestered until the challenge is ruled on. If not, then the document needs to be destroyed. So reaching a happy medium to solve process with regard to those sections. Next challenge is really addresses the procedure of when a receiving party discovers a document in a third party's production that it reasonably believes is privileged. And this is a situation where the plaintiffs wanted a fixed number of business days for the parties to notify the producing party. Plaintiffs asked for 4 days. Facebook said that it wasn't reasonable to have any limit whatsoever. The court ultimately agreed that 10 days was a reasonable amount of time to notify the producing party. Next challenge addresses procedures that applied to protected documents in deposition or hearings. And this is a really important area in this particular decision, and one that I want you to think about regularly, especially if you're in class action work and you're dealing in asymmetric litigation. A lot of times what we will find is that parties will wait until a document is put in a deposition to claim privilege. So, you know, deposition exhibits are not generally exchanged, and a deposition exhibit will be put in front of a witness, and then the party representing the witness will claim privilege and refuse to allow that witness to provide testimony based on that document. And, you know, so there are multiple issues here. In this particular instance, the plaintiffs claim that that this process will be used to disrupt deposition testimony. And at the same time, Facebook wants to ensure that a party should not be permitted to use a document that is privileged in a deposition and then obtain testimony about it. So the court looks at this, and to be honest, this is a place where I feel like we need a better process. And I'm going to suggest one in our takeaways. The court doesn't really do anything atypical here, but allows for the usual process to apply. If the privileged document is put before the witness, the party must object on the record, state the basis for the privilege claim, and demand a clawback. If the document can be redacted to remove the privilege information, then it must be done so immediately, and the witness can then answer questions on the remainder of the document. Once the privilege is raised, the deposing party cannot ask questions until the privilege claim is resolved. And then the court also addressed the need to identify privilege after deposition. So say you ask questions about a privileged document and the witness responds to them, and then upon reviewing the transcript and the exhibits, counsel realized that there should in fact be privilege applied to that document and the testimony should not have been allowed. Then the court set a 10-day limit for Facebook or the parties to respond to that, to make an allegation or to make a claim that information is privileged and should be redacted from the deposition transcript and that the document should be marked privileged. So those are all the issues raised here that you'll want to consider when you're drafting your 502D order. Those are specific instances that you want to deal with. Deposition testimony is going to be a really key one. So those are the challenges. What are our takeaways? It's really important that you understand and know the differences between Rule 26b-5, Rule 502b, and Rule 502d in protecting the production of privileged or protected material, and that you're making an active decision on whether or not to have a 502d order in your case and what the totality of that 502d order is, whether it simply says that there's no waiver for inadvertent production, or whether it goes further, as the order does in this case, to provide specific steps for dealing with individual issues where there is inadvertent production. Particularly in asymmetrical litigation where one party is producing more of the documents, you're going to want to pay attention specifically to how the process is done. In this particular issue where we talked about claiming privilege during a deposition, and you need to make a process determination on the spot of whether or not there is privilege or not, consider whether your judge can be available to resolve issues during the deposition via phone. We've often found that that is very quickly resolves issues. The other way to proceed about this is if you see a potential issue when you're reviewing documents, i.e. that privilege on a log has been claimed on common interest, or that you feel like there are issues related to business advice that's given for in-house counsel and that's being claimed as privileged, then those issues need to be raised before you go into depositions so you can avoid this very issue. We all know, if you're taking depositions, that when the flow of information gets interrupted, the flow of conversation with the witness via an exhibit gets interrupted, it's hard to get back there. You won't get the same information in a subsequent proceeding that you might have otherwise gotten. It's just, it's very disruptive to the whole process. So anticipate that disruption and plan to handle it. Next takeaway, with volumes of data on ESI, even small matters can have inadvertent productions. Use the protections of 502D. Just use them. Many states have a provision for exactly the same kind of order. If not, you can draft one and say that it is meant to be interpreted under the rules and commentary of Federal Rule of Evidence 502D. This is not something the other side should have a problem with. Both parties are always looking at issues dealing with inadvertent production. The last takeaway really here is put together a template order that makes sense for your cases and have it ready to be used in a matter. There are sample 502D orders in eDiscovery Assistant. You can also use the language from this order or other samples, which is available via PACER. Okay, that's our case of the week for this week. Thanks so much for joining me. I'll be back next week with another edition of our case of the week from eDiscovery Assistant. If you are an 𝐊𝐴𝐳𝐬 member and interested in using eDiscovery Assistant, there's a discount available to current 𝐊𝐴𝐳𝐬 members and a trial for folks taking the 𝐊𝐴𝐳𝐬𝐬 exam. If you're interested in either of those, please drop us a line at 𝐊𝐴𝐳𝐬𝐬@eDiscoveryAssistant.com and one of our team will be in touch. If you are interested in doing a free trial of our case law and resource database and are not a member of 𝐊𝐴𝐳𝐬𝐬, please just go to eDiscoveryAssistant.com and you can sign up in the upper right-hand corner to get started, or you can reach out to us at support@eDiscoveryAssistant.com if you're interested in having eDiscovery Assistant available for your organization. Have a great week. Stay safe and healthy, and I'll see you next week. Thank you.